Good afternoon. I think we're going to try to get started. We're hoping to start at 12, but I wanted to give everybody a chance to get some food. It's great to see everybody in person again. It's joined from the international section, privacy, and policy section of the George Bar. I'm Amanda Witt. I'm a partner at Kilpatrick Townsend and co-chair of our technology, privacy, and cybersecurity team. And this is a wonderful panel here of people with deep expertise in this topic. So, Michelle, do you want to introduce yourself, and then we'll just move along.
Sure. The Department of Justice, Office of Privacy and Civil Liberties.
My name is Jason Boring, Global Head of Privacy and Data Protection for Vialto Partners.
My name is Charlie Ritz. I'm the Vice President and Global Privacy Lead for Wyndham Hotels.
And then, so Charlie and Jason have deep, in-house experience with dealing with data transfers. And Michelle is actually working on the rules of the new Data Protection Review Court that's going to be part of this new EU-US framework that we'll get into. So I just want to get a feel for where the audience is in terms of dealing with global data transfers. So how many of you are in organizations that are currently transferring data globally? Good, got a good handful. And so of those organizations, how many are engaging in EU transfers to the EU UK? Good. How about Asia? How about China? How about Latin America? Oh, good. Okay, that's good. Good. How many of you registered for the Privacy Shield? Okay. Great. That's very helpful. Yeah. So this is definitely a hot topic. So we've got a lot to try to cover today. First, we want to make sure that everybody has the basics on the terminology that we're using. We'll get into a little bit on the kind of the background of where we are currently on the EU, US data transfers. But obviously, your organizations are transferring data globally. We want to make sure that we cover those, especially since this is an international event. Can't refer from the EU. And then we'll talk a little bit more on China data transfers, and we will get into a little bit on Latin America, and then we will bring you up to speed on where we are with the new EU-US framework. So, as you can see in this work, by showing hands, obviously there are a lot of, it's not just EU-US data transfers that are at play anymore. Now we have 20, basically draft or in existence data transfer mechanisms like data transfer clauses, and then we have they basically are covering right now 91 countries in the world. So if you have an intra-company data transfer agreement, that's steadily growing thicker and thicker because you've got different clauses for different countries. So it's definitely we are seeing this is a growing area where there's more and more countries that are regulating how data is transferred globally. We'll focus, since we're going to dig in quite a bit on the EU, I want to make sure that we all are on the same page on the terminology. So obviously, data transfer, that we're talking about, personal data, very broad definition. It's pretty much anything that's identified or identifiable. So it's including, IP addresses, names, anything that could potentially identify a person. And processing has a very broad definition as well. So it's, it's even, accessing, storing, and deleting it, anything you possibly do basically with data is considered processing. So when you're processing outside of that country that's being regulated with respect to the EU, you're processing it outside of GDA, then that's considered a transfer. So we also need to understand there's different kinds of data. So there's also the special categories of data, sensitive data. China also distinguishes between has a sensitive data definition as well. So kind of understanding what types of data you have, and are there special additional requirements with respect to that data? It's really important to understand. And most importantly, and this is very important to the new EU standard contractual clauses, is understanding the roles of the parties, so the parties that are engaging the data transfers, whether it's between affiliates or if it's between customers and service providers. So the controller is the entity that's making the decisions about what to do with the data. So they're usually, for example, with, say in Charlie's industry, you have maybe a hotel in Germany that they are collecting guest information, they're deciding where, what to do with that, where to store it. Then maybe they're using AWS or Salesforce as their service provider. So that they're telling that, service provider what to do with that data, so that service provider is acting as the processor. So that's really important to understand. As the two, especially deciding with respect to the EU and which standard contractual clause module to use, but it's not always so clear cut. So Jason, do you want to talk about how entities can be both controllers and processors?
Yeah, of course. I mean, as you noted, the determination is going to inform what basis you have or what you utilize for transfer, a number of other obligations that you might have in this space. A lot of times, an entity, when they're engaging with a service provider or a third party, make an assumption that they're a processor. But actually, in many cases, including with Vialto, and if you're not familiar with us, we're a spinoff of PwC, the tax, immigration, and other businesses. But we're usually a controller because we do decide what to do with the data. We do determine the purposes and means of the processing, because we're getting information. And we're saying what we need. We're making an evaluation or giving an opinion or advice on the result, the desired result from our clients. And it wouldn't make sense to say we're a processor in that we're only following their instructions, because that would assume that there is a predetermined result. And that a lot of times that's the same kind of analysis with law firms and other professional organizations. So you really need to look at what you're hiring the third party to do, what the circumstances are of the data that you're making available, how you're transferring the data, because that's all going to inform, the status. A lot of times, your individual company or client who's collecting data directly is going to be the controller, of course, but it gets a little tricky, when you're working with third parties.
And Charlie, it's fairly complex in your industry as well as to
Right. So Wyndham Hotels and Resorts is the largest franchisor of hotels in the world, with over 9,100 properties in many, many different countries. And so when you look at franchise or franchisee law, there's a lot of sort of variations on how this controller and processor, these definitions can play out. One thing I'll mention is that in the EU, for example, these whether or not you're a controller or processor is an operation of law, right? So if you choose the wrong template and you call a third-party processor, that doesn't mean that they can't still be effectively a controller, and vice versa. So generally in our business, we generally act as a controller. We use a lot of third parties to provide various services. But there are some instances with respect to our franchisees, these are independently owned and operated hotels, where Wyndham, sort of the corporate entity, is providing certain services on behalf of those individual entities. So sometimes those lines are very blurred, and I think it's critical as you think about your business, in particular transfer and processing of data, to try to really understand which role the parties are playing, and understand that you could play both roles at different points in the data processing.
Thank you. Also, just as a refresher on GDPR, so it will apply to your organization if you are established as a branch or an office, in the EU, which most of our clients don't. But if you are instead, if you are the way that we applied is if you are targeting, trying to sell goods and services to the EU, you're targeting business, you're collecting money in euros, translating a website in European language, those kinds of things, basically trying to target that market, or you're monitoring their behavior, whether it's surveillance or online tracking. So there's a couple ways it could be subject to GDPR. And then the idea under GDPR is they want to make sure that they're protecting the data when it leaves, EU countries or EEA countries. And so either basically the starting point is you can't transfer the data unless you're transferring to a country that's has adequate safeguards. So countries that have been deemed by the EU to be adequate. So you've got Israel, you've got Japan, you've got other countries that are deemed adequate. Then you also could use the standard contractual clauses. You could use binding corporate rules. You could use derogations. The way that we'll talk about the new translated framework, that's a form of adequacy in a way, and so we'll get into that. But there's basically that you have to have some kind of data transfer mechanism to get data out. And one of the areas too where we see a lot of misunderstandings about data transfers, and a lot of people on the marketing team or the IT team are like, they've got a solution, we're storing the data in View, like problem solved, like no data transfer. So unfortunately, the way that the EU use it in the guidance, the European Data Protection Board, which is the assembly of EU regulators that provides guidance on this, that remote access. So basically, say you've got the data center in Europe, the data is living in Europe, but you've got somebody out in the US providing support, or another employee that's you have that kind of third party that's accessing the data from outside the EU, that's considered a transfer. So that's very challenging in terms of like we have a lot of clients that are doing business in the EU, and there's a real strong push from the European business partners that we want you to store the data in the EU, and they want us to set up a data center. The cost is extreme, but it doesn't solve the issue either. So that's definitely a challenge generally. So Charlie, like, how would you say, like, what's the general approach to organization with just dealing with global data transfers given these complexities?
Yeah, I mean, the truth of the matter is it's very complex, and it's very easy to go down rabbit holes and try to boil the ocean. Our general approach, which we generally recommend, is identify what are the major trends, right? What's the core of your business? Try not to get lost in some of perhaps the sub-processing that you may do, or other technologies that you do to run parts of your business. We want to make sure that we solve for the most critical data that we process in the hospitality industry. That's the guest data, the reservation data, as well as the loyalty program data. So we spend a lot of time focusing and prioritizing and understanding and data mapping around our core offerings as a hospitality company. And we make decisions and risk-based approach with the way that we can transfers forward.
And Jason, what about your organization?
Yeah, I mean, I think it's really important to kind of understand Amanda's point about access being a transfer. It's really hard to have data not leave the boundaries of a certain jurisdiction, right? So we're a global company. We're in 55 countries, and a lot of times the services that we're providing are in a specific jurisdiction. But because there's a global security infrastructure, support network, et cetera, nearly every case there's going to be a transfer and there's going to be access. And so if someone's pushing for overly restrictive terms, for example, because of the scope of the work that's being done, even that doesn't quite work because of the nature of support. And so it's, to Charlie's point, it's really understanding the data, where it's going, by who it's being accessed, and solving for, what you deem to be, the most material transfers in your organization. And even if you kind of assume, well, since we're doing all this, tax work only in Japan, there's not going to be a transfer. I think if you look a little bit deeper, there can be some issues that aren't quite at the surface.
And then Charlie, also there's, I guess you have the, kind of the general data transfer with service providers, vendors, but also you have to deal with kind of the intra-company too, right?
That's right. And as Amanda alluded to earlier, the stack of papers is growing with more and more regions sort of introducing these requirements. In the case of Wyndham, we have over 150 different entities scattered internationally for various reasons, as I think most large corporations, multinational corporations would have. So it's very important as well, understanding where the data is traveling, but also to which entities are actually collecting it, which entities are actually processing it. And you want to make sure that you have the appropriate mechanisms in place between those corporate entities, because you may lawfully receive data from a third party, but then if you pass it over to one of your subsidiaries, that could be an illegal transfer. So those are other considerations to think through.
Yeah, and that's again when the status is really important too, right? Because you could be passing over the data for them to do something that they make a determination about, or say, we know you need this data, but it's for this purpose, and that's going to inform how you document it as well.
I think no area has given, or no person maybe has given privacy attorneys as much gray hair as Matt Shrum. So, Michelle, do you want to kind of give us a background on how we got to the current state of things for EU-US data transfers?
Sure. I'm going to take it first way back to the 90s. So in 1995, the EU adopted the Data Protection Directive, which regulated the processing of personal data within the EU and the movement of that data. So for the next couple of years, the Department of Commerce worked towards issuing these safe harbor privacy principles. So these were principles that prevented private organizations in the US that store customer data from accidentally disclosing or losing that personal information. The principles were based around the idea of notice, choice, protection of onward transfers, security, data integrity, access rights, and effective enforcement. And then organizations that were regulated by the Federal Trade Transportation can participate and self-certify their compliance with the Data Protection Directive through the Safe Harbor. And this enabled them to transfer EU information. The European Commission found back in 2000 that Safe Harbor would provide adequate protection, as Amanda has referred to, under Article 25 of the directive. But then in 2013, Edward Snowden revealed the NSA's surveillance of electronic communications and extensive data collection activities. We're all familiar with that. Shortly thereafter, Matt Shrim, who was a student at the time, filed a complaint against Facebook Ireland with the Irish Data Protection Commissioner. So this is Shrim's 1. Hoping not to get to a Shrim's 3. It was aimed at prohibiting Facebook from further transferring data from Ireland to the United States, with allegations that Facebook was sharing that data with the NSA. So Shrim's based that complaint on the data protection law and says that data transfers to non-EU countries do not occur unless the company meets their NCI protection. So after a series of appeals in 2013, the Court of Justice of the European Union ruled that the Safe Harbor framework was invalid, based its decision on the finding that the European Commission had failed to examine U.S. domestic laws or international commitments for consistency with the Data Protection Directive prior to determining if the Safe Harbor would be effective. So in 2016, went back to work, and the U.S. Department of Commerce and Commission agreed something called the Privacy Shield Framework. So this was a framework for regulating transatlantic exchanges of personal data for commercial purposes between the EU and the US. The same general principles as Safe Harbor, same sort of self-certification. And the Commission at that time determined that the Privacy Shield Framework was adequate to enable data transfers under EU law. Okay, you can guess what's going to happen. Shrim's complains again to the Irish Data Protection Commissioner, this is Shrim's 2. He argued that the standard contractual clauses under the Privacy Shield Framework were similar in that would transfer under the Safe Harbor, and that it would still not be adequate protection. So that essentially the government was sidestepping EU law. That case proceeded to the Court of Justice of the European Union. In 2018, the General Data Protection Regulation, GDPR, came into force. Insurance raised that Facebook's activities were not GDPR. So in 2019, the case went forward, and CJEU eventually held the Privacy Shield to be invalid. They did uphold the standard contractual clauses, but noted that without additional safeguards, those might be insufficient for ensuring that the personal data transfer sufficiently protects that data. Because the standard contractual clauses cannot bind the government authorities in the country to which personal data is transferred. So, therefore, the party exporting the personal data to the country in which government authorities have access to it needs to implement additional safeguards to ensure data protection with respect to those authorities, such as encrypting personal data or demonstrating that government authorities did not have a duty to access the transfer. General complaints there were that the legislation related to U.S. government surveillance programs were too wide and vague, did not have precise rules about the scope and application of the mechanism question, The court also said that the bulk collection and over-collection for data was too great. And then individuals in Europe must be able to pursue legal remedies to access or after their information be erased or corrected. Under the Privacy Shield, Europeans' rights to redress rely on an ombudsperson to oversee data originating from the EU is being processed via intelligence services. The court ruled that the ombudsperson couldn't fix the sort of ineffective redress because it had a political commitment to correct the violation without an underlying legal obligation. So that there was no cause of action open to EU citizens following the decision from the ombudsperson. So that's where we left it.
Yes, the whole Sherm saga in 5 minutes, right? So yes, there's been a lot of work to do on the EU data transfers the last few years. So in addition to Schrems 2, we have the update of the standard contractual clauses, the finally contemplated GDPR, and gave us additional modules. So those all had to have all your contracts updated with those new standard contractuals clauses by the end of last year. As Michelle mentioned, it's no longer just kind of just use the standard contractual clauses and do nothing more. Like, for the exporters of the data, they now have to, look into like the intelligence, the government access laws, the risks to the data that exists. So you basically have to become an expert in surveillance law in some cases in terms of researching and understanding like what risk do the laws of that particular country where you're exporting the data pose to, what are the risks of government access? Can you implement supplementary measures to reduce the risk of that access? Do you have a question?
Well, with respect to that, I mean, some of the countries in the EU have extremely vast abilities to survey their own and other citizens. Do they speak to that at all in that aspect?
It's incredible.
Great point. Great point.
And they've expanded that access since the Paris attacks. I was living in Paris when that happened.
This is something that certainly has been talked about at many different levels. I think start to shift into something that's more geopolitical, perhaps. If you look at, for example, the UK and the surveillance programs that they have, of course, and there's Brexit and all those considerations. But yeah, it's a great point that I think has been brought up in many contexts.
Yeah, Michelle, I didn't touch on that a little bit. I can touch on one too. I know you don't want to get your.
I mean, I've said that.
Yeah, I mean, I think it's been a process of education. So I think the people in the European Commission who are negotiating the new framework, like they understand that, their intelligence authorities, like we're basically going as far as their intelligence authorities are, like they're kind of match up for what, the kind of the responses that can be given. I think the problem is like the regulators and then the justices on the court might not really understand as fully as, what their intelligence authorities are doing. And, kind of they have a very, almost like an academic, like view of things that should happen or not like to actually happen. So
I mean, I do think that the US is being targeted to a degree, or you can at least make that argument, but there are some rights that
We have an active shooter on the outside of the building. Attention all units, we have an active shooter on the outside of the building.
active shooter on the outside of the building. You're welcome.
So well,
That is something interesting.
yes, let's see something.
Is that government still the credit for life? Yes.
With Dawn Radio.
I always thought this was I guess simply because always walk out the I'm saying this is always like yeah, it's all to grow with that here. You guys are just somebody didn't feel it exciting enough.
Give ourselves.
Yeah.
Does everybody want us to continue or everybody's nervous? Okay. We've locked the door.
Attention all units, we got active units in the town area. Attention to all personnel in all units. We got an active unit in the town area.
Yeah, what area?
But our side of the building is.
Outside, it'll be fun.
On the sound area, right?
The Midtown area seems a little less risky. Yes.
So, one question about that, we had trouble with the standard contractual clauses in the sense that it was unclear whether any modifications were allowed, which it makes it almost impossible to use them
Yeah.
if you can't. So,
Yeah.
is there any new information on that?
Yeah, I mean, the new modules are pretty, I mean, luckily they're modules, so they're much more usable in terms of fitting it to your particular organization. And that the guidance is pretty clear about what parts of the standard contractual clauses you can modify, like you can pick the governing law and the forum. There's some of the kind of certain provisions that are non-negotiable, and so that's not ideal, but that's why ideally, like what we usually do with our clients is we'll have a data processing addendum that will clarify, like, okay, technically you have audit rights, but we've agreed that we're gonna give you a SOC 2 report instead of like, you actually coming in and physically auditing our data center. So there are ways to kind of clarify.
That's what we want to add in the DPA sort of.
Right.
So have they been clear now on that you can do this with the clauses, you can't do this with the clauses? Like, is that, because that wasn't really.
Right, yeah, I mean, the guidance on this, it's a little bit more clear as to like what you can change and whatnot, so, but it's still, I mean, the general rules of provisions you can't change, you shouldn't be modifying, so, I mean, but you clarify things to the DPA, so it's not as onerous.
And then depends on how far you want to take the clarification. Or the
Right,
anticipation.
exactly.
And that depends on, your organization.
And I think there's some impossibilities too. I mean, if you look at the ruling with regards to SECs are still allowable, right? But the supplemental records required in a lot of instances would make a transfer of data sort of pointless.
That's exactly.
Because they would require encryption where only the sender of the data has the keys to unlock it. So it ends up in the United States, for example, nobody can unlock it, not even your own organization, right? So I think we're sort of at a crosshairs of, well, what do you do, right? I think it's a risk-based approach. There's many organizations that are headquartered in the EU that have to transfer data to the United States and other parts of the world, and they're taking approaches and proceeding in light of some of those impossibilities I think that have been outlined. Under the assumption that Michelle is going to rescue us. But it really is, I mean, there's a practicality around, well, how do we actually continue doing business based on, the little read of the results?
Have you, anybody had any, could be anybody, had any, look-ins from the commission or anything where you could see sort of how they're doing? Because what we did was we took what's the most severe subcommission in Europe, which was typically France or Greece or, yeah. And so then we're like, okay, let's meet this. And then let's see, and then we can at least say, if we get looked at, look, these are the toughest ones. We did everything possible. This is impossible. What else do you want us to do? Right. I mean,
Yeah, there's
I think there's a lot of discretion between the parties about how far they want to take it. And,
And I don't think there hasn't been a lot of challenges very specifically on organizations' use of the clock, like an actual, some sort of enforcement where we could receive some insight into how we might deal with it. But I think some of the best practice that I've heard out there is to, perform the transfer impact analysis anyway. So even if you were dinged, even if you were inspected by a regulator, you can say, listen, we did everything we possibly could. Here's our analysis. We don't believe the risk, outweighs the potential harm, that sort of thing. So,
thank you.
And On the note of what you were talking about, of having to do this sort of like almost region by region assessment. I mean, in Germany, it's crazy. I've heard some sort of rumblings from some of my contacts in Europe that there's like, they have buyer's remorse at this point with GDPR and the fact that it was allowed to be modified country by country when it was adopted. Have you heard anything more, any of you who are more steeped in this daily than I am, on an idea that it might be reformed to make it more uniform in adoption? Because I mean, it's already so.
Yeah, I mean, I have not heard anything. I know that, I mean, yeah, the whole point of doing regulation was to make it,
Right.
It's like, you know, yeah.
Yeah, I mean, they're taking some initiatives around trying to modernize enforcement.
Right.
Yeah,
Yeah.
so that means
Yeah.
perhaps trickles out to other things. I mean, you also take a look at what UK is announced and doing right now. They want to make it pragmatic
Yeah.
and workable
Yeah.
From a data protection standpoint. So it'll be interesting to see how much influence that may have on any sort of future.
Yeah.
And I see one thing from the EDPBs, the like a regulating the regulators announcement.
Right, they're trying to get some consistency.
I mean, we are also seeing though additional legislation and regulations coming out of the EU, like the Digital Services Act, the Digital Markets Act. But similarly,
What was the first one?
the Digital Services and the Digital Markets Act, they similarly just kind of rely on the member states law. So I don't know if we're near reform on that quite yet.
The AI Act, I mean, it's, yeah, the German attorney called it, you know, a legal tsunami of laws coming at us, basically, but then you would go.
But I think that Charlie's point, the data transfer impact analysis, we had a Greek attorney who was very, you know, whatever, and like, okay, this is good. And all that is, for people who don't know, is it's basically a spreadsheet where they list down all the different ways that the data transfer could impact the person. You know, it's very consumer focused for the most part. Yeah.
Right, along with the measures that you're taking to protect it, right? The standard, you know, it's going to be encrypted when it's transmitted. And
You just fill it out for here's what we can do and still make the business work.
The problem I have with the transfer impact assessments, frankly, is that the controls that are put in place are pretty uniform and they address a lot of the concerns that you'll see in a number of different jurisdictions. So for example, if you are putting in place encryption to a certain degree, if you are imposing on a third party the obligation for them to let you know if they get a request from a governmental authority, if you're doing all these things as kind of a standard basis, you still need to do the transfer impact assessment, of course. But there's a degree of uniformity in what the results are going to be, which makes it seem kind of silly.
Well, and I think there's a lot of discussion on that as well. So in theory, the way it's written, you should be doing a transfer impact assessment for every single contract/transfer that you do, right? So in practice, that becomes very onerous and operationally heavy to do, right? So what are ways we can say there's some commonalities? You can reuse the template without reusing the template if you were inspected, right?
Yeah, you can, for example, you can say, oh, well, these countries fall in this bucket, and we're going to have an analysis about, you know, the level of access or, you know, how we feel their democracy is developed or whatever else. And you can say the same thing for types of information and things like that. And so there are ways to do it because Charlie's right. I mean, technically, you have to do it literally all the time, which is very onerous for a lot of reasons. But if you come up with a way to say, well, we've at least evaluated this to a degree, you know, I think that is certainly better than nothing and showing that you've been thoughtful about, you know, the transfers generally.
I get the sense that the regulators really are just looking for that documentation. And
Yeah.
that's the one enforcement action I could think of was in Germany against, you know, a customer MailChimp that was, you know, basically said that the controller in Germany didn't do their transfer impact analysis. So that was kind of, and they didn't put in supplementary measures. And so that's kind of like what they want to see is some documentation from that. But do you have a question about that?
Yes, talking about the standard contractual clauses, for the uninitiated, can you give a little bit more background, essentially what these clauses say, when they expect them to be used?
Sure. What are the panels or?
Yeah, sure. So when they're expected to be used, they're used when you have a transfer from Europe or the UK for the UK version or addendum. that needs to have a basis for transfer. So that is to say, you can transfer data to an adequate jurisdiction, like Amanda was talking about earlier, to Japan, Canada. There are a number of places where you can just do it.
Yes.
But
this
if
is
you're-
yes.
Yeah, so we have it
Really
on the
pointed
slide
out this
as
is
well.
It kind of covers exactly what.
Yeah, and so, it's just one of those bases for, giving yourself the ability to transfer the data. And there are others, finding corporate rules, there's derogation / exceptions that are.
Yeah, so it's the idea, step one, are you transferring personal data? If the answer is yes, and you're sending it to a country that doesn't have so-called adequacy decision, i.e. the European Union has determined that their laws are equivalent in some nature to GDPR. So yeah,
Really small number, right?
which is a really small
Yes,
number of
so
countries.
most, yeah, most.
Just make it simple, if it's going,
If it's,
For US.
if it's going to the US, the US is not.
Yes.
That's all, so Europe is adequate. So-
Right, yes, outside of it, yeah.
clause, the provision with an EU company and a US company, or I get, what, can you give it a little more specific scenario?
So this is all about protecting the individual's data. So any company that is bound by GDPR, who's making a transfer of that personal data, let's just use the United States as the example, most common, right? So you're sending, and there, yeah, so some examples we can pull up. You're sending the data to the United States, okay? So the United States does not have an adequacy decision, and the recipient, so there's an individual in the United States receiving it, or there's an organization, and therefore you must enter into these standard contractual clauses, which you can think of as just additional contractual language that outline the various protections and rights afforded to an individual in regards to the protection of their data.
But he's always gonna be between an EU company and a US company. I mean, it's just a situation where you have two US companies.
You can have two.
You can have two.
One of the old SECs, one of the big problems with them was the data exporter, so the sender of the personal information, was contemplated as being a European entity in all cases. And despite that, a number of US companies were still using them, and still calling themselves an exporter. But since we've had the new
We have an active suit on West Sixth Street. The building will remain on lockdown, so the notice.
Keep going.
Yeah, so-
And then what's the review? Stop.
Yeah, generally
And it's-
In the attention, we have noticed that an active shooter on the outside of the building, notice on West Street. The building will remain locked down to further notice.
Okay, well, I do want to touch on the. The Brexit, because of Brexit, the UK has their own standard contractual clauses. They have an international data transfer agreement and then an addendum that's attached to the EU clause. The EU clause is basically just set about the protections of, what, basically the processor has to follow the controller's instructions, the controller gets to have audit rights, the regulator gets to have audit rights, if there's a dispute about the clauses, like what, jurisdiction's gonna govern that. But it's generally, we represent a lot of like American companies that are, attaching them to their agreements. But most of the time we're doing business with European entities that are, they're transferring the data to us. So that's why we have them. But there have been circumstances where you have two American companies. It's really, especially without the privacy shield anymore, there's not a lot of options for transferring data out of the EU anymore. So it's
Right, so you could have had the transfer
you have
in
privacy shield.
different bases, like the binding corporate rules.
Yeah.
Right, so if you, like I came from Ernst & Young, we had binding corporate rules in place, we had entities everywhere, and there were transfers based on those binding corporate rules that would come, to the US. It was still European personal data. So, under the old SECs, we had a bit of a quandary around like what to do then for additional onward transfers. and how to ensure that those protections carry forward. But that's been clarified to a degree in the new SCCs.
Yeah, and I don't know if anybody has the stat, but I recall a stat, I don't know if it's in this presentation, but I think roughly over 85% of organizations leverage the SCCs as the mechanism to allow the transfer. So the SCCs would present itself as the most popular or most widely used option. So if you're just starting to get into it or looking at the various mechanisms, the SCCs would be probably the place you want to start.
And do those have to be with every single subsidiary has to have a separate? So if you're a EU entity and you're transferring the data, but it's going to multiple subsidiaries, does each one have to have an agreement with SCCs?
So I think the short answer is technically yes, but I think you can organize via an intergroup transfer agreement, perhaps, and you can structure the exchange in a way that is flowing to, so.
Right.
Yeah.
Is there any new flow from anywhere on the explicit consent alternative? Because again, we were able to use that at first, and then some of this stuff came out. We're like, you can't really do that. So
I mean, it comes back to the working party guidance, which preceded the European Data Protection Board guidance, that it's not for repeated transfers. So it doesn't work for repeated transfers. But Michelle, you think about it. Okay.
We also generally can't use it internally based on that.
Yeah, we can't simply, definitely. We've touched mostly on the new transatlantic data privacy framework. Do you want to kind of just high level, and then we'll touch on some of the other countries as well.
Yeah, so I can talk about both the data privacy frameworks we're working with now, and then the CDPR, the cross-border privacy rules. So the data transfer framework. So in 2022, the White House issued Executive Order 14086, which is on safeguards for United States signals intelligence and activities. This is in response to all of the concerns in TRIMS 2 about U.S. government signals intelligence, addresses privacy concerns by introducing additional safeguards and oversight of personal data collection by signals intelligence agencies. This intelligence is called SIGINT, so I'm just going to use that term. But it provides individuals with a two-step redress mechanism for data protection concerns. So first mandates that SIGINT always be necessary and proportionate to a valid intelligence priority, and it does list in the executive order 12 specific legitimate objectives. It subjects full collection of information to tighter controls, creates requirements for the handling of personal data, and expands oversight by the Privacy and Civil Liberties Oversight Board, which has privacy and civil liberties oversight over U.S. intelligence organizations, and that helps to verify compliance and sort of remediate issues of non-compliance. The EO also expanded current practice to consider privacy and civil liberties of all persons regardless of nationality or country of residence, which has not previously been part of the process, and it creates a multi-layer mechanism for individuals of qualifying states integration organizations to obtain independent environment review and redress of complaints. So two-step redress mechanism under the data privacy framework includes the Civil Liberties Protection Officer, CLIPO, and the Office of the Director of National Intelligence that conducts initial investigations of complaints. They've issued an intelligence community directive describing how they conduct that review. And then second, the Data Protection Review Court, which is out of my office, which will independently review determinations made by the Office of the Director of National Intelligence in response to these qualifying complaints sent by individuals. The Attorney General will designate countries and economic organizations. So that kind of gets back to the point of qualifying states. So the Attorney General will, over the summer, designate countries and economic organizations, and it will work much like an adequacy decision kind of reverse. The DPRC judges will also be appointed from outside the U.S. government in consultation with the DPRC to make sure they are independent. The other sort of structure that we have right now is the cross-border privacy rule, DPR. This is an approach that has actually been pretty effective in Asia Pacific. the economic area. So current members of the APEC cross-border privacy rules that are listed up here. But this is intended to demonstrate that strong interoperable privacy protections can enhance trust and facilitate rather than impede cross-border data flows. The focus here is on accountability, outcomes, including how effective safeguards are in practice. It's more of a practical approach to transfers. So there are essential privacy protections that are government gaps. The government's involved in setting and improving safeguards. Companies then must demonstrate to a third-party accountability agent that they are complying with the rules and subject themselves to ongoing monitoring and enforcement. Conceptually, the focus here is on certification and accountability. There's a focus on digital trade with trust, which is kind of a bit of a buzzword that we're trying to lean into right now. Achievable and accountable compliance. So the CDPR forum members welcome consultations with jurisdictions that accept the objectives of the forum to try to align themselves with the requirements, tries to foster connections between countries that have developed or are developing data privacy certification. So we can cross-recognize those and build different regulatory approaches, data protection and privacy. Obviously, no process is perfect, so we're trying to scale this in a way that handles unanticipated legal or policy or regulatory hurdles. But the CDPR system is pretty flexible. Keep in mind always that the issues associated with cross-border data flows are unprecedented, almost always, and so the only solution is an iterative one where it can be perfected over time. We might just not have a solution, it's just where we've been for a minute. We don't like that. So just really important to keep the right parties in the room if are needed. One of the things that we've brought up many times is you don't have, from our perspective, like law enforcement, national security parties in the room building something like the GDPR out. It's difficult to make it function in reality. So
Yeah, that's a good point. A lot of people are saying now that really the only solution is like some kind of global treaty and global framework for these very challenging. So as even though this is just a quick diagram showing all the the countries that have global comprehensive privacy laws, obviously the US is going one state at a time right now, so it's not with yeah, so they generally, it's not all EU as we mentioned earlier. So it's we've got the general kind of politics that are going on with the EU and the UK that the UK has their own clauses, but now China has released their own model clauses and their privacy law came into effect in November 2021. Brazil has their own GDPR law that will basically, at some point, they said it will be easier, not as complex as the EU standard contractual clauses, but eventually they're going to have their own data transfer mechanism. Argentina has had its set of clauses for a long time, so that it's part of many data transfer agreements. But China is definitely where people the action is of late. So, Jason, you want to kind of bring us up to speed on how do we deal with China data transfers?
Yeah, China is where the action is. China's modernizing its data protection regime, and there are new restrictions and bases for transfer of personal information out of China. So generally, if you are known as a critical information infrastructure operator, so that's banking, healthcare, et cetera, you are restricted from transferring data out of China. If you meet certain thresholds that are set forth in the new law in China in terms of quantitative volume thresholds, then you also have similar restrictions. I think it's 1 billion records transferred or 100,000 records as of January 1st from the prior year, or 10,000 sensitive records from January 1 of the prior year. You are subject to this certification that needs to be done, an assessment by the Chinese regulator, the CAC, that you're automatically kind of in that bucket. And we are preparing to do that. And I understand that Charlie's organization is in the midst of that now. If you are below these thresholds, there are certain other kind of bases for transfer, and that's an assessment by an external organization that is approved by the CAC. Also, China's version rather of the standard clauses, which in a lot of ways are very similar to the European clauses. In some ways, they're not substantively, but can be the basis for transfer, except that they have to be filed with the CAC, which is a huge
Every
pain,
time,
frankly, every single time. And the CAC in those cases is not going to presumably take a substantive review of those SECs, because in addition to the SEC or the standard clauses that you file, you also have to file your contract and the assessment that's required in connection with entering into those clauses. But it does mean that the CAC is going to have access to them, and if there's an issue, they can leverage that in terms of any kind of evaluation or enforcement. I also think it must be said, and this is fair, that it's also a highly political process in China. And so, kind of knowing how to navigate that process, having local resources, kind of understanding what the best option would be, I think is particularly important, as you're doing this security assessment with the CAC, or you're doing these internal assessments and filing them in order to give yourself a valid basis for transfer out of China. It's been a bit of a moving target in terms of when the enforcement's going to be. If you are currently transferring personal data out of China that is prior to June 1st, you actually have an additional 6 months, which I'm very thankful for, to get everything buttoned up until the end of November. If your organization starts transferring personal data outside of China after June 1st, I think it's immediate. So just things to keep in mind when you're, evaluating China, in addition to, a number of other jurisdictions. But I think the complexities there are substantial.
And Charlie, did you work with local resources and you filed your?
We did. And we found in the market, having local resources that know how to navigate CAC at the state and federal level was essential. Some of the particulars, I can't share all the particulars, but some of the things that we got pushback for were very much procedural in nature, versus substantive based on, the various impact assessments that we filed. So having somebody on the ground locally that can help grease the wheels and understand the language and the process, I would say that that's essential to being successful.
Grease the wheels legally.
Yeah.
Are these different standard contractual clauses or the same?
They're different.
And nobody's going uniform around it.
So, Argentina is pretty uniform with the old SEC.
Right.
Yeah.
Substantively similar?
Substantively similar, certainly. A couple differences. There are additional obligations on onward transfers.
The individual rights are never described exactly the same.
They don't make a distinction between controller processor either, which is one of the things we said was important, but not as much for China.
I think in China, the law also has some various exclusions around the government's use of surveillance, right? So there's carve-outs to allow them to continue to surveil their data subjects that otherwise other organizations couldn't. So those types of things are in there, but yeah.
Right at one, but I guess nobody can leave anyone, so. We'll continue. Charlie, you want to touch on your experience in Latin America as well?
Sure. So the party extends to all parts of the world. And so in Latin America, I think there's probably two major markets to sort of consider when we're talking about standard contractual clauses and international data transfers. So starting with the one.
Attention. We have a report of an in the area, last known location around the Northside Hospital. Please proceed to your safe location. The police are on the scene. This is not a drill. Attention. We have reports of an armed person in the vicinity of the Northside Hospital. Please proceed to your safe location. The police are on the scene. This is not a drill. Further updates will be forthcoming. Thank you.
So I, folks that maybe haven't seen it, I've been getting updates from my wife. I think it's 1100 block of West Street. So it's,
Oh, it's like a clinic?
it must be a satellite. Satellite.
The Google SGR building.
What's that?
It's right across the Google SGR building. By Whole Foods.
Yeah, it's 2 blocks. You can see it from here. You can see the intersection.
It's on
The police are all set up.
Yeah, so not the north side.
So not this block, but presumably we are.
Two blocks away. It seems like, you know.
Go straight to this.
So anyway, Charlie.
So yeah, switching the focus back to Argentina and Brazil, like the two sort of major jurisdictions to consider. Argentina, is sort of an interesting case study because they've had privacy laws in the books for quite some time, right? So first enacted in 2000. In 2016 is when they came back and issued, I think there's 2 forms of standard contractual clauses to be utilized for various purposes. You see sort of the similar themes. There's a little bit of differences, but there's similar themes. You can't transfer to a non-adequate country, which Argentina, I believe, has adopted a very similar list to, which is inclusive of the EU as well as a few other countries. The United States is not on the list, so that's a common theme. But you can only transfer data if you get express consent from the individual, or if you have the SECs in place, or if you have another mechanism such as binding rules that have been put in place. You see a similar, yet I'd say less mature restrictions in Brazil. So the regulator in Brazil, once again, there's certain restrictions on data transfers. They actually have not published, as of yet, a list of the countries that they deem adequate. So it'd be interesting if the thing holds true in the United States is excluded from their list or not. But once again, things are a little bit less clear, but they're like a similar model to Europe with these various clauses that should be utilized in order to do these transfers.
Covered up to this slide earlier, but yeah, there's basically got a helpful example here. Hopefully the slides will be useful. Just in terms of a checklist, I think that in terms of probably Jason already kind of touched on this, understanding the data you have, where the transfers are, who are the relevant parties, understanding which laws apply, with say mentioned, prioritizing the high risk transfers, getting all the correct documentation in place, and then doing this transfer impact assessments are definitely important to do. But there's still a lot of headaches and challenges if you've been following the Google Analytics decisions out of the EU. Like it just feels like any data transfer to the US is pretty much violating GDPR because you're using sub-processors. Google, which their Google Analytics data hasn't even been requested by the NSA, but Google generally provides data in these kinds of requests. So they're basically, even if you're as an entity not directly subject to these laws, FISA and whatnot, if you're using processors that are, then the regulators seem to have an issue with that, which is definitely causing headaches.
And then, do you know if Amazon also readily provide?
Yeah, they have a transparency. Yeah, most of the big tech companies do. And they really.
I just wonder if there's somebody that they might look at as a little.
It's Microsoft took it all the way to Supreme Court. That's why we got the Cloud Act. It's very hard to resist these requests generally.
I chair privacy and cybersecurity subcommittee for ACC, and we had people from Microsoft and Google to talk about how they respond to these requests at one of our meetings. And I mean, they have a pretty strenuous process that they go through to object to requests for data from the government. And they said that in terms of percentages, the percentage of requests that they get that are actually for enterprise users' data it's like infinitesimally small. So I mean, this perception that we have that there's a massive, trolling of, in terms of the NSA and governmental authorities, seeking enterprise data or even individual customer data from Microsoft and Google, it is just not accurate according to what they.
Right. Michelle, I think there was like a report issued recently that said the FISA requests were down like dramatically by 90%. Yeah.
Oh, I got fresh.
Yes. The perception is worse than the reality.
Yeah, they also have links on their site about like
You can see which countries are accessing
those
to.
requests and even they issue information about the number of requests they get and
They'll show which countries are requesting to.
Yeah.
So yeah, this transparency reports are very interesting. So let's get into the mechanics of how this data protection review will work. Michelle, if you want to touch on that.
Yeah, and then first slide, I think it's just the background that kind of been through, but got here from one insurance to process, executive order that reference earlier is linked here, as well as the Attorney General order, which established the BDRC. And that supplementary, the bottom of the last slide is the intelligence directive. So I'll just try to walk you through how this process works. This is as simple of a flow chart as I possibly could pull together for this, but so basically it starts off with complaint from an individual. So just to sort of define this, the complainant, just the only definition is natural person. So it's not a regular citizen, it doesn't have to be a US person, just a natural person. But a qualified complaint. So they would submit a complaint to the member states of the EU or to the countries, essentially, I think it's going to be the Data Protection Authority, who will review and determine if the complaint meets the qualified complaint criteria of the executive order. That's a complaint that's submitted in writing that alleges a violation that is covered by the order pertaining to personal information of the complainant. The complainant must reasonably believe that that information was transferred to the U.S. from a qualifying state after the Attorney General designated that state. The complaint must relate to something that would adversely affect the complainant's individual privacy, liberties, and interests, and it must have been a violation of one of the laws, orders, or statutes or procedures that are articulated in the executive order. Examples are the Constitution, the FISA, or Executive Order 12333. I won't get into it. Must include information in the complaint that forms the basis of the allegation, what kind of relief is being sought, and which U.S. government entities are believed to be involved in the violation, and any other measures the complainant has pursued to try to get the relief requested. That doesn't sound like a lot of context, but we do actually have privacy protections in the government, so we can't just pull Michelle Ransom's information and pull up a bunch of things from the intelligence community. We have to have some context to be able to figure out whether we have the information or not. So if we do have a qualifying complaint, then the member state, in this EU sort of example, authority would refer that complaint to the Office of the Director of National Intelligence, the Civil Liberties Protection Officer, CLIPO, as I mentioned earlier. So the CLIPO will ensure that they agree that the complaint meets all the requirements necessary to conduct a redress review, and then depending on the allegations in the complaint, will request that the privacy and civil liberties officers of the relevant intelligence community elements provide information necessary to investigate a qualifying complaint. The intelligence community is pretty vast. It's, NSA, CIA, many associated smaller agencies. So they'll work with the privacy and civil liberties officers, which are embedded in each of those agencies, to make sure that they have all the information necessary. They might seek clarification or further information from the intelligence community about any of the field intelligence or the agents. Then that CLIPO for the ODNI will determine whether a covered violation has in fact occurred. And if yes, they will determine the appropriate remediation. So they will consider what the complainant has requested, whether that's feasible, what they can do, and will issue a codified written decision report to the Assistant Attorney General for National Security. that intelligence community elements involved must comply with that decision. So they decide that the agency needs to delete the information, they must delete it. We will follow up and make sure that actually happens. The thing that's frustrating for many people, I think, is that what they'll do is then send a GLOMAR response to the complainant. If you're not familiar with that, that is a response that says that we will hear confirm or deny the existence of the information sought. Then if it does exist and there was a violation, you fixed it. Yeah, so people don't like that. The courts have ruled that response to have merit if the secretive nature of the material requires it, and only if the agency provides as much information as possible to justify that response. This is one of the concerns that's been articulated by the European Data Protection Board in the opinion issued in February. It can be really frustrating to not actually understand how it can be turned out. We emphasize that in this case, the intelligence is actually highly classified. Some degree is best that we're going to be able to do, but there are mitigating factors like the independence of the DPRC, the review of the process by the Privacy and Civil Liberties Oversight Board. There are also special advocates embedded in the process that advocate the interest in the matter to ensure that the panel is up to date on all relevant issues of law. So once that decision is made and a GLOMAR response is issued, the individual may then decide to appeal that decision, not knowing what it is, of course, but may decide to appeal that decision to our office, to the Data Protection Review Board. So there, it's sort of the last little area here on the slide. We will review the ODNI determinations that are made in response to the qualifying how the determination is made. We don't know how many complaints we're going to receive. That's one of the questions we get. We have no idea. It's a pretty high bar, actually. A qualifying complaint is not that easy to pull together, so it probably won't be millions like that. But you never know. So we are prepared for any eventuality there. But the DPRC consists of 6 or more judges that have been appointed by the Attorney General from outside of the U.S. government. They are not subject to the supervision of the Attorney General, and may not be subject to adverse action for their service on the DPRC except for ours for cause. So they are relatively independent. Each application for an appeal will be reviewed by a 3-judge panel of the DPRC that's convened by my office. The presiding judge over that panel will select a special advocate to advocate for the complainant's interests. The special advocate, again, is not an agent of the complainant and cannot communicate all the details with the complainant, but it does act on their behalf in this process. The DPRC panel of judges will determine whether the ODNI is legally correct and supported by the substantial evidence in the case, and whether any appropriate remediation was consistent with the executive order. And whatever the DPRC decides and the IC must monitor. We will then send another really helpful GLOMAR response to the complainant. Just kind of further background on the DPRC. So my office of Privacy and Civil Liberties, sort of an offshoot of the Office of the Deputy Attorney General. We will help facilitate the advocates. We've been drafting a procedure report. We'll receive field appeals and gather the ODNI record review. Make sure that we maintain confidentiality, the information transmitted to the procedures, securely maintain the records. We'll share information about the DPRC like I'm doing right now, in the process of filing an application for review, and we provide other support for the DPRC. So I know there's a question about the timeline on this. Whenever the Attorney General is able to designate covered countries, DPRC will be ready to go. We anticipate right now that's going to be sometime in the summer, but you never know, it's the government, so we're ready to go.
But although the GLOMAR response sounds unsatisfying, but it's consistent with what the EU intelligence
It is, yeah.
do. So it's, I mean, it's basically giving equivalent protections to
Right.
what
We're
they would get the EU.
obviously not going to write a response back that says, yes, Charlie, we were surveilling you. I think you did. We were wrong. We're not going to send.
There's a greasy in the wheels in China.
Yeah, but
On the list.
yeah, And I know that that's really frustrating, but it is done very much in good faith. We have a pretty robust privacy structure in the federal government, particularly in the intelligence community, that is full of a lot of checks and balances and really checks itself in many instances. We have all learned a lot of lessons in the past 10 years. So,
What's the accountability for the special advocate?
what do you mean?
Well, they're gonna advocate for the complainant who they never can really talk to and don't have a relationship with an agency for, and they have independence inside. So, I mean, what's their incentive? If I'm working as a special advocate, what's my incentive? It's like, public defender, but worse. It's like people can at least see the public defender, right? So,
Yeah, so the special advocates, again, like they don't work directly with they do, but they don't provide information to the complainant about here's what the government's processing on their behalf. But their entire purpose in being there is to make sure that the panel that is considered a complaint is aware of all that relates to the complaint. So that's essentially their entire function. They don't have, they don't go to the complainant and provide all the information about what's going on, but that's, again, not really feasible in these situations. So kind of one of the best things we can do is just have independent voices that are throughout every stage of this process. They don't have to report back to the Attorney General either. So, at the same point.
Like an inspector general.
Yeah, that's their entire role in the process, is just to make sure that everything that's relevant to the case is being considered.
thank you, Michelle.
Yeah, and I think also just to clarify so that the framework, but it's not available to be signed up yet, because we've got right now, it's still going through kind of the EU process where, the European Data Protection Board, which is the organization with all the regulators, reviewed it. I'll let Michelle give her commentary, but, it's kind of like there were things that, they begrudgingly noted that there was some improvement, but obviously some issues. Matt Schrems has already said he's going to challenge it. Also, the European Parliament has given their input on it, and they weren't super enthusiastic about it either. Like Michelle, you wanted to kind of take how that feedback has been received, I guess, internally.
So there's a lot of things to consider as we're moving forward. We have read the European Data Protection Board's opinion. It's not that unfavorable, actually. In our opinion, we presented the framework to step forward, and it has to be basically carefully watched, and oversight has to be implemented, and we have to make sure that oversight is actually being done, and that's fair. That's what you expect of the government, is for people to be accountable. That's something that you're evaluating from this system. So we're confident that we're going to be able to fill sort of the ask there. The European Parliament Committee on Civil Liberties, Justice, and Home Affairs, the committee did issue a rejection of the data privacy framework in April. From our perspective, the finding contained pretty key misunderstandings of the framework and some deep assurances. So we're going to keep trying to clarify that. At the same time, I'm not worried for Parliament. We statements in that process from members of Parliament on the lines of, if we can't find out if it's for the US, then we can be. There's always critical voices, but European Commission on Justice Rangers said while we're quite sure there will be a legal challenge, please test the system before you say it's inefficient. So that's kind of our ask right now.
We've heard from German counsel, a couple weeks ago that he is frustrated, that there's such a focus on the US transfers when he's way more about what China's doing, so it's definitely very frustrating. But the US has gone as far as possible. I mean, by agreeing to the necessary proportionate limitations of terminology the EU wanted us to use, like that it's very significant. So I think that everybody outside of the regulators and the justices maybe seen, and some German parliament members, I guess, recognize that this is as far as they can go. But Jason, Charlie, do you think that your organizations will sign up for the new framework?
I expect that we will. The underlying principles that inform the framework are things that are good, right? Things that we should be doing. To a degree,
I think it shows our commitment to those principles. You know, whether we leverage it to the same extent that we might have leveraged Privacy Shield or its predecessor is a different question, because you know, there's always the risk of it being overturned again. And until there's something that's more permanent or seemingly permanent, I don't think that we'll use that as the basis, or at least the only basis for transfer. But I think there are a lot of positives.
Yeah, and I mean, we're gonna proceed with caution. You know, I think many organizations, you know, got burned by Safe Harbor, got burned by Privacy Shield, as their only reliance on managing this particular issue of data transfers. So, you know, we're gonna watch this unfold. As Amanda said, I was in Washington, D.C. the other week at the International Association of Privacy Professionals Conference. Max Schrems was there in the flesh. Can't say I didn't have some of the leg moments, thoughts. He did mention, he was very clear. I mean, he was on a panel. He was very clear that there will be a 3, and Max Schrems 3, 4, 5, 6, 7 in perpetuity until he feels like he's the correct monster. So I think that puts organizations in a predicament, right? You have to make some choices, and I think we'll probably explore, as Jason alluded to, setting up some things in parallel. We certainly would not be afraid of subscribing to the principles and, you know, abiding by them, and so just balancing the operational lift to, you know, do the registration and do the self-certification and whatnot, versus the practicality of it actually being upheld as a lawful mechanism, right? So we're just going to proceed.
I think that's a good way to approach it, because until it survives Schrems 3, it's kind of hard to count on it lasting. So I think kind of a belt and suspenders approach of, you know, signing up the framework and then also keeping the standard contractual clauses in place until we figure out whether it will last. Michelle, do you think it's going to last, or what's your prediction?
I mean, what am I supposed to say? I think it's the best that, you know, we have to offer. So I hope it does. I really can't imagine the government has really gone out of its way to try to meet this requirement. I can't imagine. I'm sure they're quite honestly more constitutional frameworks. So yeah, I'll say yes. Perfectly fine. I think that we're very optimistic.
Question mark?
What would our time frame for a Schrems 3 look like? I mean, if this is gonna be in place for 2 years, maybe?
Yeah, I mean, do you have a feel for that? I know he wants to challenge it before it's even. Yeah,
So
it'll be an immediate challenge.
Probably, what, 18 months worth of procedural,
Yeah.
you know, back and forth before something. Yeah, so it could be a couple of years.
Well,
for sure.
yeah, I mean, I think too, like, you look at, so basically next week, Ireland, the regulator in Ireland is going to finally issue their Meta decision as to whether they're going to stop data transfers for Facebook Meta from the EU. So that's been going since, I think it was filed right after GDPR.
Yeah.
So that's been going, 3 years, but it has lots of challenges. But I think, you know, if it took, I think with the Privacy Shield, probably about 2 years, yeah. So, but I know that he's planning on challenging it immediately, and so I don't know what kind of priority will be given, but yeah, so somewhere between 1 year and 2 years probably.
Well, and isn't his current sort of focus on cookie regulation?
Yes, he's done a lot. He's filed like over 100 cookie enforcement actions. So yeah, that's the other thing. You know, I think that privacy advocates used to kind of think, oh, it's great, he's getting, you know, GDPR enforced, but now it's just like he's wasting all the regulators' resources, you know. So it's like
He's focusing on the important stuff.
yes, his profile. I think it is. Yes.
We're gonna make money in the middle of all this.
Dollars and cents somewhere.
Yeah, but yeah, it's definitely, I mean, the regulators are swamped as it is, you know, they deal with breaches, they deal with, you know, random data subject complaints, but yeah, they're getting hundreds of complaints from this one, you know, Max Schrems organization that NOIB, so it's definitely challenging. But Jason, Charlie, do you have any thoughts on, like, as, you know, kind of in-house counsel, what do you think is most challenging about dealing with data transfers?
I want to stick with our original answer here. Everything. That, in all honesty, it's just hard keeping up with all of these developments. I mean, this is a a moving target. You know, ChatGPT can't help you because it's September old data, you know, unless you subscribe and give up your data for it. But you know, it's just you as an in-house counsel, we want to provide the guidance to the business that says we feel confident that this would be the appropriate decision. That, you know, we'll leave it up to you, but here's the risk and here's the current state of this particular issue. But when the issue changes, I mean, just the amount of momentum and inertia and all these different forces to present this topic to leadership and then for it to change like 3 weeks later, it's really exhausting. And it's very hard. You know, I deal with it every single day. So I feel like for me, it's very hard to keep up with what is the latest and greatest and how do I have to advise the business. But for my stakeholders, my clients in the organization, they hear from me, you know, once every couple of weeks, right? So they miss a lot of these developments and having to sort of rehash it out is extremely difficult. Operationally, the paper trail is extremely difficult to manage. You know, we have thousands of contracts, right? It's not, if there's updates that need to be made, whether it be for US state laws or international laws or data transfers, you know, we have a pile of thousands of contracts. I'm sure many others in this room, you know, face the same challenge. So how do you, when things change every 3 or 4 weeks or every 3 or 4 months, how do you convince the business that we need to go through this exercise yet again and again and again? It's like, I thought we already did the standard contractual clauses. Well, you know, there's another template that doesn't exist today that theoretically is going to get created that requires some rework. So I think that's the hardest part, is just trying to stay on top of it.
Yeah, I agree with that. And the lack of understanding, right? Not only at the leadership level, but just throughout the organization and, yeah, with the parties with whom you're working, right?
Yeah.
And so if they don't quite understand it.
I don't think I've had a single negotiation with standard contractual clauses, just the idea of to include them or not to include them. With various third parties, the understanding is all across the map. And I don't claim that I have the silver bullet or the answer that can clearly explain it for everybody, but I'll see that the interpretation of the requirements, the interpretation of the clauses, and when to use them, how to use them, controller, processor, controller, etc., is all over the map. So I think, an incredibly difficult topic that organizations struggle with across the board.
I have a really unfair question, but is there any way, since we're here, stuck here indefinitely, is there any way to quantify that personal data is that significantly much more safe, or there are less breaches, or is anyone even tracking that European data is more safe, or people's data that is based in Europe is more protected now because of GDPR or because of Schrems 2, or at some point it became more safe? Is anyone looking at that? Is that been
And I think it's
quantified
probably
somewhere?
like a rights-based analysis rather than a how safe is it, right? Because how safe it is depends on the level of security. And, you know, one of the things that is evaluated when you're doing transfers would be like the controls that are in place, which include the security controls. But I think from Europe's perspective, particularly, it's making sure that the rights that are associated with that data are preserved, and less about making sure we have as few incidents as possible, which is certainly a concern, but it's more caring for it, you know, as a fundamental right in Europe more broadly, and ensuring that that's respected in a number of other jurisdictions.
But it's a fair question. I mean, I think there are examinations. We're coming upon the 5-year anniversary of the enactment of GDPR. And so the question is, and this was discussed at the IAPP conference in DC, has it met the goals that sort of were originally thought that it was designed for, right? And these are open questions. So your point, I think, is extremely valid. Jason's point is extremely valid too. It's, I think it's cultural nature, the idea that as a European, I want complete control of my data. I don't want it to be sent. It's not even so much about it gets breached or it doesn't get breached, but it's the control of this is my property, this is my data, and I don't want these other organizations, these other companies, I don't want it sent anywhere because this is my fundamental right to control control those things. And so the question is, does GDPR advance the position of those rights with respect to the data subjects in those regions? I think it's a great question. I mean, perhaps you can sort of sense my position on a lot of these issues, but I would probably argue the answer is no. I think about the cookie banner, pop-up banners. Are those an effective mechanism to protect rights of individuals? I would argue that the answer is no.
I do think it's risk awareness though, right?
Yeah.
So that's really the, so pre-GDPR, there was not as much focus on these individual rights and what you could do with your data, the extent to which you could limit processing, the extent to which you could ask for deletion. And so the profile has certainly been raised. And, if that is the goal of GDPR, then I think to a degree that's certainly been successful. Yeah.
And organizations have had to, totally revamp how they're handling data in terms of like understanding the data flows and being more aware of like, do we need to send it to this particular vendor? I think generally, I think there's been a lot of, so you'll see, I think a lot of the discussion around the UK updates is like, has GDPR really worked? Like, what's working, what's not? But, I think Charlie's points too, it can feel like the only thing that's changed are a bunch of pop-ups, but, I do think that organizations have really like matured over, how they're handling data and how they're protecting data. And we're seeing, kind of as this pushes into the US and, there's, Americans, we want more control of our data. The Washington Act that was just passed, we're getting more protections as to like who is actually getting access to your data, and understanding that and whether, I think the federal problems of, trying to look at what will work at a federal level is, like, do we want to like kind of make blanket prohibitions on certain kinds of like data brokers and what they do with the data, or do we want to just kind of adopt what's been adopted in other places thus far? But I do think data transfers, it's a daily issue for organizations that we're advising. So, with clients that before they go into, do business in the country, they want to look at, what are the data transfer and localization requirements in certain countries. India has been trying to pass, privacy law for years now, and they were, hovering around the potential localization. Now it's more, they're going to have certain blacklisted countries, but that's an issue. And then we also, we have provisions in our contracts with a particular client that does a lot of business internationally that gives them the right to terminate the agreement. The laws change to require localization or prohibit data transfers because it can be so disruptive to have to localize data in a country or have to deal with data transfer issues. But yes, it's not an easy issue. Are there any questions? Like I know we've had questions about.
I mean, first of all, thanks for the last several years of all of this. You've been doing a very helpful job. Thank you. But I don't know if you have growth clients or kind of startups or anything in that range, but I was wondering if you have any insight. Charlie and Jason both mentioned repeatedly the burden of doing a lot of this stuff, and companies that are either in accelerated growth or that are in a small business going to medium or large, it's very, very difficult. And that's where I was the last 3 years, just to try to budget the resources to do a good risk balancing job. And you're dealing with typically a small board and so, A, is there any insight in that? B, are there other resources like DLA Piper country by country site, and how are they keeping up? Is that working pretty well? Thoughts on that?
In terms of resources, IAPP is great. I think on tracking.
Yeah.
The International Association of Privacy Professionals, IAPP, so they have probably the most.
I would say superior. I mean, not to throw DLA under the bus or whatever, but their tool for a while was out there, and some had great summaries. But I'll be perfectly honest, I've found it hasn't been updated at the pace. The IAPP has dedicated teams that are publishing and reviewing the material that gets released. So that's my one, my go-to one-stop shop for information and sort of updates in the privacy space. So.
We do give like risk-based advice on, based on the size of the client, the size of the company. So yeah, for startups that you're just really getting going, part of it can be, maybe let's not do business in the EU yet, or, like realize that this is a risk, but the regulators are totally swamped, and so these are the kind of the high level things you can do to get in place to kind of, make it look like you're at least, aware of GDPR, like you're really doing the right things. Yeah, I mean, not every organization is gonna, do extensive data mapping and have all these things in
I have
place.
a friend who works, it's a startup company or a smaller company that's experiencing growth, but they do sort of the breaking into phones. And it's a product that is breaking into phones. It's a product that they sell to,
Show the Chinese.
to US law enforcement, right? So unlock iPhone and all of that sort of things. They have technology around that. They want to expand into Europe. So they're smaller, but the risk base, the answer is yes. They're going to have to bring in a team to really get their ducks in a row, obviously, because of the sensitivity of data. So I would say, in addition to Amanda's comments, understanding what data you process, understanding the definitions. Each jurisdiction has a different definition of what in the United States we traditionally call sensitive data. In Europe, it's called special categories of data. China's definition of sensitive data is a little bit different. The new state laws are changing the perception and definitions of sensitive data in the United States. It used to be your name and your social was sensitive and pretty much nothing else was, or your credit card information, right? But now those definitions are expanding. So understanding whether or not your data that you're collecting and processing is in one of those categories and then focusing on it.
Well, and to your point about the board too, like it is really expensive, right? So, when we spun off PwC a year ago, and when we spun, we had nothing in terms of the data protection program because it was all stayed at PwC. And so, part of the charge was to build it and coordinate with the board and let them know what's important and what's not, and how much it's going to cost. And it costs a lot, right, in every single area. But you do
Time too, and
yeah,
people.
time and resources, teams, and whatever else. But by communicating with leadership or the board or whomever about what's important, what you can do that's sort of good enough if you got in trouble, and things like that. I mean, that's really where the hard conversations are, particularly if you're asking for money.
It's interesting too, you almost, the sample that Charlie, you just gave, that if you're going into that market, right? You could do a financial model analysis, and you could actually do a capital raise based on, and then include that whole thing. And I mean, if you got to do it, you got to do it. So that's.
Yeah, I want to pick up on something Charlie just said about sort of the character or nature of the data. I mean, is there any in your risk analysis or your risk-based approach or whatever? So, for example, if you only do B2B, and so like the only PII that you have is people's business person identifying information, like is there,
all right, I think you're probably asking, is there a scale within, so personal data, perhaps non-sensitive, is there a difference between business contact information versus customer contact information? Right. And the short answer is I say absolutely yes. Would the regulators agree with me? Perhaps not, right? But you look at risk in that context, right? So this is somebody's business contact information, and generally the B2B, the number of records you have in a B2B context are generally smaller versus, for example, in the hospitality world, I mean, we have 100 million transactions a year, guests, members traveling and passing their data back and forth, where they stayed, perhaps what their rentals were, like in the room and stuff like that, versus this is very much the only way we can do business with another business is to have some sort of conduit contact information, right? So in different organizations I've worked for in the past, we have definitely considered that as one of the factors as we write it up and have our documentation. Once again, are the laws written in a way where it makes that distinction clear? I'd say the answer is no. But I think at the end of the day, trying to build risk-based approach, defensible program, if you presented that we analyzed this, a regulator came and looked at it and said, listen, we looked at this, the number of records is small, this is the only way we do business, so on and so forth, I think there would be some leniency.
I think, yeah, I mean, technically, that all applies, right?
Right.
Absolutely. So, but I think you can also make a determination if it's appropriate for your organization to say, well, if it's only business contact information, we're not gonna run a PIA, and we're not gonna do a TIA, we're not gonna do all these other things because, you know, to Charlie's point, it's just, you have to have somebody's email to coordinate with them, or the purchasing agent or whomever, and just kind of categorically say, we think the risk is so low, we're not even gonna worry about it, we're gonna focus our energies elsewhere.
Yeah, and I've seen this come up in negotiations often with, especially on the sourcing contract side. So sourcing, you usually have some sort of contact for invoices and, you know, so we will receive this just crazy data protection addendums. And we're looking through it and it's like, what are we protecting here? It's like, oh, well, we have our contact information so we can get paid. It's like, oh, okay. But those are real, you know, so it's like, if we're having those conversations on these very basic use cases, you can only imagine when you start touching special category sensitive data, how much more complicated.
It gets to the misunderstanding
Yeah.
that everybody has, right? And so people will impose, or entities will impose obligations that perhaps are not appropriate. And I think it's fair to push back. Like, we get the same thing. Like, if I get that, and where it's business contact information, tell them, you know, we're not gonna sign it, we're not gonna even engage on something like that because it's not necessary.
Thank you all for attending. I wanted to give you the last announcement I got from the office. So, so they're saying we're still locked down. The incident occurred, this is about half an hour that I got this announcement. The incident occurred at 10 West Peachtree on the North Side Medical Center. There are injuries. The suspect has not been apprehended. We're in direct communication with building management and the Atlanta Police Department. Please remain in your defendant place location. We'll continue to provide updates. So, I guess all welcome to stay here. Fortunately, Michelle's got, she do a call, so I'm gonna take her to another room real quickly. Other than that, I think we can stay here and it's panelists have a meeting yet, so you're free to go and come. But